All right, so this is another video in the continuing series of the statute of limitations in foreclosure cases, one of the hottest topics in all foreclosure defense litigation. The question that exists is whether or not the statute of limitations that exists in collection cases is going to be made to apply in foreclosure cases. Now, we had the Bouvet opinion out of the third DCA where the court said, no, statute of limitations, hard stop, even though this is a $1.4 million mortgage. If you don't file within 5 years, the bank is out of luck, you can't collect. We had this opinion that appeared previously to the Bouvet opinion. This is U.S. Bank versus Bartram. In the Bartram panel, the written opinion found that no, banks are special, mortgages are special, and the statute of limitations does not apply. Each new payment is a new default, so they can keep filing. Now, the important thing to understand about both of these opinions, and one of the most interesting facts, is that in both Bouvet and Bartram, the dismissals were based upon the bank's attorneys just failing to show up at court. Now, think about that for a moment and consider the equities there. These are banks. These have all the money. They've got all these lawyers out there, and these cases get dismissed because their lawyers just decide not to show up. I think that's powerfully important. That goes into the substance of these arguments there and the equities that the banks try to argue. So even though the bank's lawyers failed to show up, what you have at the 4-minute 20 mark is the bank lawyer saying, hey, judges, you don't understand what's happened down the trial courts. It's so hard for us because these pesky defense attorneys are challenging everything. They're challenging us on the letters. They're challenging us on procedure. And, you know, that's the job of a defense attorney. So I find it a bit amusing that the bank attorney is asking for a little bit of relief. They're begging for some sympathy, but the court's not buying it. And you get the full expression of that coming at the 9.54 mark where the judge says, if the bank can't figure out how to foreclose on its mortgage between 2006 and 2011, it's hard for me to feel much sympathy. And the judge says, you know, look, we've all practiced law, and quite frankly, it's not that difficult. I just can't understand why the bank can't get around to foreclosing on its mortgage over all these years. That's really a telling exchange right there, and that's really speaks to the problem on the plaintiff's side, the bank attorney's side, and expresses what we all understand right now, and that is this is not so much about defense attorneys really pushing the banks, but the banks just falling asleep at the switch. That's exactly what you see here. Now, I really love the demeanor of these professionals that are appearing before this panel on all sides. You got a good bank attorney, you got a very good homeowner attorney in Mike Waslick, and I give this panel a heck of a lot of credit. Pay attention to the demeanor and the treatment of these judges. Very, very refined, very, very dignified, giving full respect to both sides, and especially to the homeowner side. You don't get any of the what we call the deadbeat homeowner problem. You don't get criticism or critique of the fact that the homeowner hasn't made a mortgage payment. That critique slips into many of these arguments. You don't find that anywhere here. You've got this panel giving serious consideration to all sides of this argument. Quite frankly, I think the exchange that you have between the homeowner attorney and the bank attorney is quite encouraging. You'll see at the 26-minute mark a very lighthearted exchange between the panel and the consumer attorney. The consumer attorney is asking for a written opinion on this very important, very serious matter, and the panel looks at him and he goes, "Will you take a PCA?" A PCA means a per curiam affirmed, and he, responding to this good-natured exchange, says, "Hey, if you want to give me a PCA, I'll take a PCA." And quite frankly, given the negative opinion that comes out, we would have preferred a PCA rather than this written opinion. But again, a lot of credit here to the professionalism and the exchange that occurs. Pay attention as well, again, on both sides, both the bank attorney and the homeowner attorney. You see a very professional exchange. You don't have lawyers stepping on judges' comments. You don't have judges stepping on lawyers. You see a very good exchange with both parties getting the full expression of their thoughts. And even you see the extension of the time afforded on both sides. The panel is giving both sides a little bit more time. That's because both sides are engaging in this. The panel is very engaged on both sides of the argument, so they're willing to let the time spin out a little bit more than elsewhere. But again, the exciting thing about this, or the substantive thing about this, is you have an acceleration in 2006, and it's not until 2012 until the bank gets around to doing something about it. But pay close attention here, and pay particular attention to the written argument and the written opinion that comes as a result of this very good oral argument.
We're on U.S. Bank versus Bartram. All right, so let me get this reset. Okay, you may proceed.
Good morning, Your Honor. May it please the Court, my name is Richard Swank. I'm with the firm of Baker Donaldson. We're here on behalf of the appellant, U.S. Bank. We would submit to the court that this is an extremely important case, particularly in the current climate. Because of the historical way in which foreclosures have gone about, there is a dearth of case law out there. It's kind of smattering all over the place. A lot of it relies upon dicta. There's never been a direct case that has a holding that would decide the case that we have here today.
You agree the third DCA's case, although it was dicta, arguably, it could be dicta, could be viewed as one of alternative holdings, that case would appear to be against you.
The Spencer case? That's correct, Your Honor, but the Spencer case doesn't bring into account the Singleton case or the Olympia case. And I would direct the court's attention to some of the supplemental authority that we filed since the filing of our brief. The Crondis case, the Neal case. Crondis was out of the 4th DCA, Neal was out of the 1st DCA. And then the Kahn case out of the Southern District of Florida, which of course is only a persuasive authority, not precedential, but I would say that that's virtually on point. And the Spencer case does not take into account the Singleton case or the Olympia case, and it does rely upon
Singleton. I know that I've read Singleton, and I know about the language in there that you're relying on. But Singleton is a res judicata case.
That is correct, Your Honor.
And it has to do with issue preclusion, actually. I mean, it doesn't even mention the statute of limitations.
No, it does not.
So you have to take the language in there and apply it and say, okay, well, if it applies to issue preclusion, then it necessarily applies to the statute of limitations, right?
I think so, because I think it goes to the question of equity, which Singleton directly addressed.
Of course, while a foreclosure is an equitable proceeding, statute of limitations is an issue of law, and except for things like equitable tolling or fraud, usually equity doesn't come into calculating a limitations period, does it?
No, not usually, but in this particular case, it comes down to the decision about when the supposed acceleration of the loan occurred.
Well, there isn't a supposed acceleration in this case. I mean, your complaint, even if there had been no acceleration letter, and I don't remember if there was or not, but your complaint clearly says we elect to accelerate the balance due, doesn't it?
In the prior case?
Yes.
I believe it does, yes, Your Honor, although I don't know that that was part of the record in this case.
As to whether or not the bank elected that remedy.
There is no dispute that it elected that remedy, but there is a dispute as to whether there actually was a valid acceleration, because without a valid default, there cannot be a valid acceleration. And in this particular case, the court dismissed.
You put in your complaint, the complaint says that you elected to accelerate. The complaint says that, doesn't it?
Correct. But just because we allege it doesn't mean that it actually occurred. I mean, it's in the current foreclosure climate, Your Honor, there's a great deal of controversy on virtually every single stage of the foreclosure. Borrowers are challenging whether they received a proper default letter, whether the default letter properly stated what it was, what the remedies were, whether there is standing, things along those lines.
Arguing that under the Singleton case that it's disputable whether there was an acceleration, but the facts clearly indicate that you did accelerate the note and the mortgage, right?
Under the Singleton case, I would argue that maybe the acceleration argument doesn't matter anymore, because under the Singleton case, particularly as applied by Crondis and Neal, they don't even get into the question of whether there was an acceleration. They mention it in Singleton, but they never go into it. And Singleton says we can imagine a situation under which there might be res judicata in this particular case. But then it goes on to talk about how...
What's the purpose? The purpose of the acceleration is to allow you to declare the entire amount, unpaid amount of the note, due and payable at that time because of the prior defaults on the prior payments, right?
Correct.
All right, and you did that in this case.
We attempted to, yes.
Well, you put it in the complaint and you pled it.
Correct.
And everybody was operating under the allegations in the complaint that you had accelerated the note and the mortgage, the payments under the note and the mortgage.
In the prior case, I believe that was the case, yes.
All right, but you're saying that that's questionable, and you're saying Singleton doesn't make it questionable. What makes it questionable then?
Well, what makes it questionable is the fact that the borrower in that case controverted the prior foreclosure, said that we were not entitled to foreclosure. And if that's the case, if they could prove that there was no default, then regardless of whether we sent a letter electing to or filed a lawsuit electing to foreclose, electing to accelerate, there's been no adjudication of that.
Well, it was dismissed, wasn't it?
Yes.
All right, and the trial court, I thought, made it clear that it was dismissed with prejudice.
No, without prejudice, Your Honor.
Well, I thought he made it clear that it was with prejudice in his subsequent order that he entered. You're just saying he didn't have jurisdiction to enter the subsequent order, right? Didn't he enter an order saying it was with prejudice?
I don't believe so, Your Honor. I think the prior was without prejudice.
It says dismissed on its merits.
On its merits.
I still believe he said without prejudice, Your Honor. I could be wrong, but I'm fairly certain it was without prejudice because of failure to attend a case management conference.
Did he say it's dismissed on its merits?
I don't believe so, Your Honor.
Let me see if I can find this. Go ahead with your argument.
In any case, getting back to the equity argument, when you have a mortgage, basically the expectation of the parties when they enter into the mortgage.
Getting back to Judge Orfinger's prior point, we're talking about the statute of limitations here, right?
Correct.
That's not an equitable proceeding. That's not an equitable argument, is it? It's a matter of law. Either the statute of limitations was exceeded or it wasn't. So where does the equity argument come in here?
The equity is whether the acceleration was effective, or whether that even matters. I mean, what the equity comes down to is that, as set forth in the Singleton case, each subsequent default can form a different cause of action. When the parties go into a mortgage contract, the expectation is that the borrower has 30 years in which to pay this obligation. He takes possession of the property, he takes title to the property, and then the bank has a lien against the property for those 30 years. If the 30 years goes on and he continues to make the payments as he's supposed to, eventually the lien will be resolved, and he'll take possession of the property. But if he doesn't do that, if he doesn't pay for it, then the bank can elect to accelerate and elect to go forward with the lawsuit. Now, he has a remedy.
In a normal case, you would agree that the effect of an acceleration is that it says, okay, you can't pay us over the next 30 years, you got to pay us right now.
Correct.
And so why isn't that an election of remedies that you had a choice, you had several alternatives. You could have done nothing, and assuming that you acted within the statute of limitations, that would have been okay. You could have sued on each payment as they became due, or you could have accelerated and said, you owe us the entire amount now. So if you choose that latter, you owe it to us now. I mean, why isn't that just the general, you elected your remedies, you're stuck with it?
Because then the borrower has a remedy under the mortgage contract to reinstate the loan by paying the default amount. Now, if you're precluded from going back further than 5 years because of a prior election to accelerate, then that benefits the borrower because he doesn't have to deal with those 5 years of payments that he didn't make.
It's hard to feel like the equities, this is one of these deals where when you think about the equities, if a bank can't figure out how to foreclose a mortgage between 2006 and 2011, it's hard to feel very much sympathy for them or equity for them. I mean, we all practice law. It's not that hard.
I would agree, Your Honor, except for the kind of unique situation in this particular case where the former wife was named as a defendant in the case, and the foreclosure counsel in the prior case twice attempted to get summary judgment. And both times, the court thwarted that on the grounds of the priority argument that the prior wife made, which she then raised in a separate lawsuit while the first lawsuit was still going on. Now, another issue with...
It's an easy way to handle it. You set it for trial. The court makes a determination.
Well, that's correct.
That's what trials are for. I mean, I'm trying to figure out, other than the fact that there's a tremendous unjust enrichment here, if the guy gets a $650,000 windfall, it's hard to feel any sympathy for the bank. I mean, if you can't figure out how to foreclose a mortgage in 5 years, and I don't mean you personally, but if the bank can't figure it out, they're never going to figure it out. If we gave them 10 years.
Correct, Your Honor, but in this particular, in the current climate, and again, I'm bringing in fact patterns that don't have anything to do necessarily with this particular case. It used to be that 5 years was a reasonable time in which to take care of all of this. I doubt that very many foreclosures lasted more than 5 years. But in this current climate, 5 years is not unusual at all. With the amount of, and this goes back to the other observation in Singleton, that if you say that an acceleration automatically starts the clock running, then all of a sudden now you've created an incentive, two negative incentives. One, you've created a negative incentive on the part of the bank to say, okay, no more loan modifications, no more, we're not going to settle this case with you. We've only got 5 years. It's going to get done. That's it. And then you create an incentive on the other side, which Judge Schwartz observed in the Spencer case. You create an incentive on the other side to simply say, okay, if I can hang on to this for more than 5 years, if I can throw up one thing after another, interlocutory appeals, bankruptcies, et cetera, get 5 years, and then somehow get it dismissed after that, free house. And so it creates these negative incentives on both sides. And that, I think, is where it goes to the equity, and I think that's one of the things that Singleton was talking about.
So your argument is it doesn't really matter if it was dismissed on the merits or whether it was with prejudice or without prejudice. It just doesn't really matter.
I don't think under Singleton it does, but I mean, like for instance under the Stadler case.
Here's what I was getting at. In this particular case, the dismissal was ordered pursuant to 1.420B, the involuntary dismissal rule, and it's pretty clear that when you dismiss under that rule, it's an adjudication on the merits unless the dismissal order specifies otherwise, and this order didn't specify otherwise. And so it seems to me like this was an adjudication on the merits when it was dismissed under that rule. And if that's the case and it was adjudicated on the merits and you had accelerated, then how are you able to come back after the statute of limitations had expired and continue on with the lawsuit?
Well, then we go back to the argument later on in the brief that even if that were the case, the mortgage was still subject to the jurisdiction of the court under the former wife's lawsuit. There was never any time when a circuit court did not have jurisdiction over this mortgage. And I don't know if you can say dismissal of one automatically triggers, invalidates the mortgage and says you can't defend yourself in the other mortgage, which is essentially what the other foreclosure, which is essentially what they're saying here.
Let me ask you this, can a notice of acceleration be revoked?
Yes.
Okay, how can it be revoked?
I believe by sending a letter to the borrower that the loan is being decelerated and that they're going to go forward with the obligation.
Okay, can it be revoked as a matter of law in some way other than, not a notice saying I'm revoking my notice of acceleration, but can it be revoked in some way as a matter of law?
I hadn't considered that, Your Honor, but I can't think of any way off the top of my head that it would be revoked as a matter of law. I mean...
So when the judge dismissed your case, for failure to appear at a pretrial conference or whatever, was the notice of acceleration still outstanding, or was it revoked, or what?
I think that because there had been no adjudication granted with the way that the prior order was worded, I just don't think that you can make the factual statement that it was established as a matter of law that there was a default and an acceleration. I would also point out that...
I think the way this order is worded, it doesn't say without prejudice, and so that constitutes an adjudication on the merits, from what I can see.
Okay, well, I would also point out, and ultimately this probably isn't going to make any difference, that this order was not in front of this court when it made this ruling. One of the arguments that we made in our case was that, in our brief, that the order was kind of deficient as to exactly why the court was ruling the way it was ruling. It basically just said, I find that the note and mortgage are invalid and I'm canceling it as a matter of law. It doesn't say what it reviewed, doesn't say, it does say that it reviewed the summary judgment and the affidavits in support of summary judgment.
What did you do in this case after that order was entered? What did you do with that?
Which order?
When, after the order was entered dismissing the case, what did the bank do then?
The prior case?
Yeah.
To my knowledge, they didn't do anything.
For how long?
I don't know because the other case had been filed.
That was it. And then how long after that order of dismissal was entered did you file this one?
After that order of dismissal was entered?
After the prior case, the order of dismissal was entered, and then how long did you wait before you filed the other case?
We didn't file the other case.
Well, you're talking about two separate cases, aren't you?
Yes.
Okay. What's the second case?
The second case is the case we're in right now.
Right. How long after that happened? What's the time frame? Was it after?
The wife's case.
The wife's case had already been filed by the time the first case was dismissed.
Okay, but are we talking about 5 years or not? Is there any doubt is there any question that the 5-year period has run? That's what I'm trying to get at.
If you're talking about the second case, I don't believe it had run by then.
I think what he's trying to figure out is, assuming that the default occurred when you alleged in your original claim, it's clearly been 5 years from then.
You would concede, that's all I'm trying to, you concede that, right?
Correct.
Okay.
Yes, Your Honor. And I forgot to reserve time. I'd like to reserve my remaining time for rebuttal, if that's okay.
Okay, you have 3 minutes left.
Okay.
A little over 3 minutes.